is resumed. At the dinner break, debate on Part 2 was in progress, and the Honourable Leanne Dalzell has the call and has just short of 4 minutes. Honourable Leanne Dalzell.
Mr Chairman, I'm thrilled to know that I have so much time left in this call, because actually the next point that I wanted to make is quite a substantial one. My first point, because I know that the Honourable Member... Oh, no, I can't mention the fact that you weren't here, you just did, but I could mention the fact that you didn't listen to that part of the contribution that I made. And what I was talking about was when the the transfer of employees occurred under Clause 15 of the bill, where employees who were employees of Westpac Banking Corporation, the member probably doesn't realise, but we've got Westpac Banking Corporation New Zealand, which is the branch of the Westpac Banking Corporation, which is incorporated in Australia. They then become employees of Westpac New Zealand, and that is, of course, a New Zealand incorporated company, which is actually the purpose of this legislation related to, which is because of the local incorporation provisions of the Reserve Bank, which were introduced in the earlier part of the century. About 2004, I think, finally the decision was made that Westpac had to incorporate in order to meet the provisions of the new requirements. And in fact, in 2006, we actually dealt with a similar piece of legislation. The Honourable Member would be probably really interested to know that that piece of legislation was in the name of Marion Hobbs. Yeah, so which is an interesting piece of history which we've already traversed, but now that I've brought you completely up to speed, I'm sure that the Honourable Member would like to participate in this debate, because I know that that member will have a lot of questions that she would have for the member in the chair. Mr Chairman, though, before the dinner break, though, I was seriously talking about the transfer of employees, one from the other, and whether that would create an inequity for those that were currently employees of Westpac New Zealand, potentially because the Westpac Banking Corporation New Zealand, the branch of the Westpac Banking Corporation, may in fact have better wages and conditions of employment than Westpac New Zealand. But I wasn't sure, and maybe the member in the chair could advise us of that. But the next point that I was going on to was a question that may not have been dealt with as an issue by the Select Committee, because it may not have been an issue when the legislation was going through the Select Committee, and that is the status of qualifying financial entity, which is a new status that has been dealt with under the financial advisors regime. We have, of course, authorised financial advisors, AFAs, under that new regime, being registered as we speak. But, and this has been quite a surprise to me, there have been a lot more institutions who've taken up the role of qualifying financial entity under that regime than I had anticipated. I thought the banks would take up that role. I thought that maybe some of the insurance companies would take up that role. And maybe some of the larger financial institutions would take up that role, but I really didn't think that we would have 200 or 300 qualifying financial entities, which apparently we do have, and thereby limiting the pool of talent, really, taking up the authorised financial advisors status. So the point that I wanted to make was, what if the Westpac Banking Corporation New Zealand have registered as a qualifying financial entity, and the Westpac New Zealand has made, Mr Chairman,
Honourable Leanne Bell.
If Westpac New Zealand has also taken up the status of qualifying financial entity, the thing that I find absent from the bill, and that's why I'd like the member, and I did actually alert him to this before the dinner break so that he could undertake some in-depth research over the dinner break in order to be able to answer this question, which I know he's now been waiting for 1.5 hours. But the question is this: if both of them have independently obtained qualifying financial entity status, does that now merge when it's not mentioned in the bill, or will they have to then reapply Or will it be automatic that those employees that cross over to the new entity will be picked up by the qualifying financial entity status? Because there's been quite a fundamental shift, and that fundamental shift involves the transfer of assets and liabilities, which of course is the whole purpose of the legislation. So, I mean, I personally think that this is quite a fascinating question. It's one that I hadn't thought of until I felt compelled to do so, and as a result, I think it is a question that really ought to be answered by the member and the chair. So I hope that my little heads up that I gave him before the dinner break commenced has served as a basis for checking that matter out, and I'm sure he will be able to share the answer with that to the House. Now, the member, when he did take a call earlier on, did comment about the application of provisions relating to taxes and duties. And I know that what he was telling us was that this is completely neutral as far as the tax liability goes one way over the other, and is making that absolutely clear with reference to the detailed provisions of the legislation. And I thank him for that, because I think there was a genuine concern raised by another colleague of mine about the capacity for this sector not always to do the right thing when it comes to ensuring that their full liabilities are met in that regard. So, and I do accept the comments that he made in that regard. Now, there was another element in relation to this, which was from a banking customer's point of view. And I know that the legislation says that there's kind of this seamless transition from a customer perspective, but I just wondered how that was going to be handled by the bank in terms of notifying that to their customers who previously were being looked after by Westpac Banking Corporation New Zealand, and then transferring to Westpac New Zealand, which of course is the registered company in New Zealand. And does the member and the chair know how the Westpac plan to communicate that to those customers? Obviously there's quite a significant change to how that might be addressed. And I think it would be useful to have that on the record of the House as well, because I'm sure that the member concerned, both in his role as promoter of this bill but also as the chair of the Finance and Expenditure Committee, would have in fact dealt with that with respect to how the customers themselves were going to see that. And it was interesting, as I understand it, Westpac have actually ensured that some options are available to their customers with respect to this transfer, and as I understand it, that Westpac New Zealand Limited are going to be in a position to make some advice directly available to customers on the basis of them asking for that in terms of the 7th anniversary. But I really would like the member to talk about the 7th anniversary and how relevant that is to the particular issues that are raised in this bill, because it is a little bit unclear from the submission that I've read about why the 7th anniversary is a particularly relevant date in terms of the application of that. Now, I do understand that Westpac wants to make sure that they cause as little or no disruption to their customers, and that's important, but I also think that it's important from a customer perspective, and as I've already disclosed, I am a customer of Westpac. I think it is really important that customers do know that they are going to be advised in specific detail about what the consequences of this legislation will be.
Stuart Nash.
Thank you, Mr.